All right. Hello, everyone. Good evening. We're here to talk about the remarkable case, the constitutional crisis of the Abrego Garcia case. It's multiple court systems, it's multiple district courts, it's multiple orders and different things. We're only going to take a look at one order in Judge Boasberg's proceeding. Not sure if I'm pronouncing his name right. He's in Texas, or excuse me, he's in the District of Columbia, which is the controversy, because the removal proceedings were taking place in Texas. So eventually, it had to be a habeas corpus case brought before the correct court. But Judge Boasberg's order has found probable cause for contempt proceedings, criminal contempt proceedings against the Trump administration officials responsible for Garcia's removal and the other plaintiffs in the case. It's not just Garcia. Responsible for his removal or their removal against the judge's temporary restraining order, which had been issued while the planes were still in the air, and the Trump administration continued with the removal proceedings despite the court's order. It's a little bit long. I'm only going to read the first 14 pages and then maybe the last 3, and I'll explain the contempt proceedings in between. And then we'll look at the judge's order, what's going to happen next, and we'll also talk about whether this has ever been seen before in the history of the United States. Let's get to the memorandum opinion written by Judge Boasberg. On the evening of Saturday, March 15th, 2025, this court issued a written temporary restraining order barring the government from transferring certain individuals into foreign custody pursuant to the Alien Enemies Act. At the time the order issued, these individuals were on planes being flown overseas, having been spirited out of the United States by the government before they could vindicate their due process rights by contesting their removability in federal court as the law requires. Rather than comply with the judge's order, the government continued the hurried removal operation. Early on Sunday morning, hours after the order issued, it transferred 2 plane loads of passengers protected by the TRO into a Salvadoran mega prison. As this opinion will detail, the court ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. The court does not reach such conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses have been satisfactory. One might nonetheless ask how this inquiry into compliance is able to proceed at all, given the Supreme Court vacated the TRO after the events in question. That court's later determination that the TRO suffered from a legal defect, however, does not excuse the government's violation. Instead, it is a foundational legal precept that every judicial order must be obeyed, no matter how erroneous it may be, until a court reverses it. If a party chooses to disobey the order rather than wait for it to be reversed through the judicial process, such disobedience is punishable as contempt, notwithstanding any later revealed deficiencies in the order. That foundational rule of law answers not just how this compliance inquiry can proceed, but why it must. The rule reflects a belief that in the fair administration of justice, no man can be judged in his own case, no matter how exalted his station or righteous his motives. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. To permit such officials to freely annul the judgments of the courts of the United States would not just destroy the rights acquired under those judgments, it would make a solemn mockery of the Constitution itself. So fatal a result must be deprecated by all. As just noted, the injunction in question was issued on the evening of Saturday, March 15th, a day of events that moved at breakneck speed because of the government's apparent effort to remove individuals more quickly than the judicial proceedings in which it was actively participating could keep pace. The day prior, the president had seemingly signed, yet not made public, very important point, not made public, a proclamation invoking the Alien Enemies Act. Through that 1798 Act, Congress granted the president broad authority if there is a declared war with a foreign nation or government, or if a foreign government has perpetuated, attempted, or threatened an invasion or predatory incursion against the territory of the United States. In such a scenario, and if the president makes public proclamation of the event, he is authorized to apprehend, restrain, secure, and remove any natives, citizens, denizens, or subjects of the hostile nation or government who are 14 years or older. In his proclamation, President Trump announced that the government would use the act's authorities to apprehend and remove members of Tren de Aragua. Apologies if I'm not pronouncing that correctly. A violent Venezuelan transnational gang that had recently been designated a foreign terrorist organization. To support that finding, the president asserted that the Venezuelan government of Nicolas Maduro indirectly relies on Tren de Aragua and has been infiltrated by the gang. He further announced that Tren de Aragua had committed or attempted an invasion or predatory incursion upon the United States, including through drug trafficking, mass illegal migration, and irregular warfare, though he provided no examples of that last point. Although the proclamation was not published until 3:53 p.m. on Saturday, defendants had begun setting act-based removals into motion weeks earlier. Beginning in early March, the government interrogated Venezuelans in its custody about alleged membership in Tren de Aragua and transferred many of those it deemed gang members to El Val detention facility located outside Harlingen, Texas, not far from the Mexico border. The reason for staging them together at El Val became clear on Saturday, early that morning when the signed proclamation was still hours from being disclosed to the public. The government reportedly loaded scores of Venezuelans onto buses, drove them to a nearby airport, and began putting them onto 3 planes. As the planes sat on the tarmac, officials refused to answer the deportees' questions about where they would be taken. Among those queued on the tarmac or placed onto planes that morning were the 5 plaintiffs in this lawsuit. Apparently catching wind of the impending proclamation, they filed suit at 1:12 a.m. on Saturday, before the buses left El Val, and then moved for a TRO, preventing their removal under the proclamation. In addition to asserting that the proclamation lacks a legal foundation, each plaintiff adamantly denies that he is a member of Tren de Aragua. Around 8 a.m., this court learned that it had drawn the case through the court's random assignment system. Chambers reached out to locate government counsel. Less than an hour later, plaintiff's counsel informed Chambers that at least one plaintiff was reportedly already aboard a removal flight. Having not yet heard from the government, and given the exigent circumstances prompting the need to freeze in place the status quo until a hearing could be held, the court entered an ex parte temporary restraining order preventing defendants from removing the 5 plaintiffs for 14 days. Not long after the TRO issued, at 9:40 a.m., government counsel informed Chambers by email that the TRO had been disseminated to the relevant executive branch agencies. Sure enough, several of the named plaintiffs report that they were abruptly removed from the planes. Evidence that defendants were able, if they wished, to ensure that people on the ground knew relatively quickly of developments in the court proceedings. At 10:15 a.m., in an email thread including Chambers and counsel for both sides, plaintiffs asked the court to hold an emergency hearing on their pending request to provisionally certify a class comprising of them and those similarly situated, and issued a second TRO covering the whole class, so a class action lawsuit. The government objected that a broader injunction and a hearing would be premature, and it asked the court to wait until Monday for a hearing. The government notably did not respond to plaintiffs' pointed question about whether it was prepared to halt removals pursuant to the act in the interim. So just after 11 a.m., the court set an emergency hearing for 5 p.m. that same afternoon. Shortly after the proclamation appeared on the White House website at 3:53 p.m. And about 45 minutes before the hearing began, plaintiff's counsel informed Chambers that he believed the two flights, both operated by a contractor used by Immigrations and Custom Enforcement for deportations, were scheduled to depart Harlingen that afternoon. Counsel expressed concern that the flights might immediately take off with his 5 clients and members of the potential class on board. The government offered no response. And in the 5 p.m. hearing, the court clarified the limited scope of the TRO then in place and turned to whether it should provisionally certify the class. The government began by objecting that venue was improper. Plaintiffs' claims could be raised only through a petition for habeas corpus in the Federal District Court of Texas, where they were being held, not in D.C. Noting that it would benefit from further argument on that issue, the court pivoted to addressing plaintiffs' concerns about imminent deportation. It asked the government point blank whether there were any removals under this proclamation planned in the next 24 to 48 hours. Government counsel said that he did not know, but that he could investigate and report back. Plaintiff's counsel then interjected that various sources had informed him that the 2 removal flights were scheduled to depart that afternoon and may have already taken off during this hearing. So at 5:22 p.m., the court adjourned the hearing until 6 p.m. and directed the government counsel to find out whether the government was in the process of removing people under the proclamation. It was. Although the government has refused to provide details, all evidence suggests that during the short window that the court was adjourned, 2 removal flights took off from Harlingen, one around 5:25 and the other around 5:45. Those later discovered flight movements were obscured from the court when the hearing resumed shortly after 6 p.m. because the government surprisingly represented that it still had no flight details to share. When pressed, the government counsel stated that the operational details he had learned during the recess raised potential national security issues, so they could not be shared while the public and press listened to the hearing through the call-in line. He suggested, however, that the government could provide the court additional details in an in-camera setting, so sort of in-chambers or in-person hearing. So the court arranged to do just that. It disconnected the public line so that only counsel for the parties were present and asked the government counsel to report. He did not. He clarified that the only additional details he had just mentioned could eventually be provided later in camera, but he had no intention or no information to share at that time. With the growing realization then that the government might be rapidly dispatching removal flights in an apparent effort to evade judicial review, while also refusing to provide any helpful information, the court turned to the pending legal issues. After hearing argument, it was first determined that venue was proper, and it next provisionally certified a class of plaintiffs covering all non-citizens in custody, subject to removal solely under the proclamation. The court then addressed the sole remaining question whether it should issue a broader TRO covering the entire class. It concluded this was appropriate because plaintiffs had satisfied the factors governing emergency relief, and because the distinct possibility, unrebutted by the government, that flights were actively departing or planning to depart, required an immediate order preserving the status quo. The court therefore ordered that for 14 days the government was prevented, from conducting the removal of any non-citizens in its custody solely on the basis of the proclamation. Then, at about 6:45 p.m., the court delivered an oral command clarifying what compliance with the TRO meant. It directed the government to inform your clients of the order immediately and to notify them that if class members were on a plane that is going to take off or is in the air, those people need to be returned to the United States. However that's accomplished, whether turning around a plane or not, disembarking anyone on the plane, I leave it to you, but this is something you need to make sure is complied with immediately. The hearing adjourned at 6:53 p.m. Roughly 30 minutes later, the court memorialized the TRO in a written order. That order referenced the just concluded hearing and reiterated that the government was enjoined from removing class members. Despite the court's written order and the oral command spelling out what was required for compliance, the government did not stop the ongoing removal process. According to defendants, the 2 planes that took off during the adjournment departed U.S. airspace before the court's 6:45 p.m. oral command. and landed abroad sometime after the court posted the minute order at 7:25 p.m. A third flight reportedly took off from Harlingen at 7:36 p.m., but the government maintains that all aboard were removed under authorities other than the proclamation. The first two planes, those carrying members of the plaintiff class covered by the TRO, apparently touched down in Honduras at 7:37 p.m. and 8:10 p.m. and remained there for several hours before taking off again for El Salvador. After the planes landed in El Salvador shortly after midnight on Sunday, most of the passengers were apparently transferred into one of that country's prisons known as the Center for Terrorism Confinement, or CCOT. But not all passengers, it seems. One Venezuelan woman swears in a declaration that she was on one of the flights that landed in El Salvador, but was flown back to the United States along with 7 other women, apparently because Salvadoran authorities on the ground refused to accept female prisoners. Her account is corroborated by a declaration from a Nicaraguan man who avows that he was also on board one of the removal flights but was returned alongside the woman because Salvadoran officials would not take custody of Central American nationals such as himself. By mid-Sunday morning, the picture of what happened the previous night came into clearer focus. It appeared the government had transferred members of the plaintiff class into El Salvador's custody hours after this court's injunction prohibited their deportation under the proclamation. Worse, boasts by defendant intimated that they had defied the court's order deliberately and gleefully. The Secretary of State retweeted a post in which, above a news headline noting this court's order to return the flights to the United States, the president of El Salvador wrote, "Oopsie, too late," with a crying emoji, like crying laughing emoji. A filing submitted by defendants on Sunday afternoon failed to dispel any concerns that they had flouted the court's injunction, so the court set a hearing for Monday, March 17th to determine what had transpired over the weekend. The court expected that at that hearing, defendants might explain that despite appearances otherwise, none of the people on the first 2 flights was a member of the plaintiff class. Or at worst, defendants would admit to a grave mistake, explain how it transpired, and detail plans to rectify it. The United States government took neither tack. Rather, what followed in the ensuing days was increasing obstructionism on the part of the government as it refused to answer basic questions about what had happened. Questions that were all ultimately in service of resolving one key fact: whether members of the plaintiff class, that is, non-citizens removable solely on the basis of the proclamation, were transferred out of the U.S. custody after this court's injunction preventing their deportation. Stonewalling started before the Monday hearing. Just before it was set to begin, defendants sought to cancel it as unnecessary, an incursion on executive branch authority. Nowhere in their filing did they dispute that class members were transferred into Salvadoran custody hours after the injunction issued. Instead, defendants set forth several hyper-technical legal arguments for why, in spite of that fact, they had complied with the court's order. Such arguments were as unconvincing then as they are now. In the hearing itself, the government refused to provide any relevant facts. The lawyer the government sent to the proceeding, conveniently not the counsel who had appeared before at the TRO hearing, repeatedly stated in some form or another that he was not at liberty to disclose anything about the flights. Although he would not say that such information was classified, he claimed that it could not be shared, even ex parte, with the court because of diplomatic concerns and national security concerns with flight patterns and things of that sort. That is, the government maintained it could not share any details about the flights, even privately with the court, despite the fact that the previous day defendants had retweeted a 3-minute video that portrayed a host of operational details. In high definition, the video displayed the planes and the runway where they were parked, how migrants were restrained and transported, the faces and uniforms of many detainees, guards, and officials, where the vehicles apparently entered CCOT, and the inside of the prison. So on Monday evening, the court ordered the government to submit another filing the next day, seeking to accommodate defendants' national security concerns, vague as they were, yet nonetheless needing answers on how members of the plaintiff class had been transferred into a foreign prison hours after the injunction issued. The court directed the government to explain its position on whether and in what form it will provide answers to the court's questions regarding the particulars of the flights. The court again offered that such information could be provided in camera or in person, including in a classified setting, so in chambers. In their March 18th response, defendants reiterated their various arguments for what they should not have to share, why they should not have to share information related to the flights, but conceded that if they were ordered to do so, they would submit an in-camera and ex parte declaration. The court ordered defendants to do just that by noon the next day, and it set out 5 basic questions that the declaration needed to answer. When the 2 flights took off, from where, when they left U.S. airspace, when they landed in a foreign country or countries, what time people subject solely to the proclamation were transferred out of U.S. custody, and how many people were on the flights solely on the basis of the proclamation. Defendants then reversed course entirely. On Wednesday morning, the 19th, a few hours before their deadline, they moved this court to stay its Tuesday order on various grounds. Most relevant, they asserted for the first time that they were considering invoking the state secret's privilege over the flight details and needed more time to make that determination. The court was unsure how answering its 5 questions could jeopardize state secrets. Defendants, after all, had publicly shared images of the flights, making them trackable, and still not claimed that the questions bore on any classified information. But nonetheless, the court nonetheless sought to accommodate their last-minute request. It gave them one more day to answer the 5 questions or to invoke the state secrets doctrine. Thursday the 20th, the government again evaded its obligations. Rather than invoke the privilege or answer the questions, it submitted a short declaration from an ICE officer stationed in Harlingen. It was his understanding, he said, that cabinet secretaries were then considering whether to invoke the privilege. In response to this wholly inadequate response from a low-level official without any actual knowledge, the court required defendants to submit a declaration from someone directly involved with the cabinet-level discussions and gave defendants 5 days to indicate whether they were invoking the state secrets privilege. The government has since invoked it. The court also directed the parties to brief whether defendants had violated the court's TROs. That briefing is complete, and the court held a hearing on the matter in early April. Yes, it's March and April. In parallel to the investigation of defendants' compliance have been further proceedings on the TRO's merits. After briefing and a hearing, the court denied defendants' motion to vacate the TROs. It held that plaintiffs had shown a likelihood of success on one of their core claims, i.e., those subject to removal under the proclamation had a due process right to challenge the government's determination that they were removable, and that they would face irreparable harm if the TROs were dissolved, a harm that also tipped the balance of equities or fairness in their favor. The Court of Appeals then rejected defendants' request to stay the orders, raising concerns with both the applicability of the act and the lack of due process. The Supreme Court subsequently vacated the TROs on a narrow ground. It held that challenges to removal under the act must be brought through a habeas corpus proceeding. Real quick, habeas corpus means produce the body. So habeas corpus means like we're going to talk about this individual's rights, bring him to court and we're going to evaluate his rights. Not as plaintiffs did through the Administrative Procedure Act, and venue lay in the district of the member's confinement, not the D.C. court. While the Supreme Court split on the venue question, it unanimously held, as this court did when declining to dissolve the TROs, that those subject to removal under the Act must be allowed to challenge their removability in federal court before being deported. So the Supreme Court unanimously confirmed due process, which is just the short legal phrase for the legal process that is due to you under the U.S. Constitution. Every single person subject to U.S. jurisdiction, not just citizens, Every single person has the protection of the U.S. Constitution, and everyone is due the appropriate legal process for the thing that's happening. You get more due process or more process due to you if there's a complicated legal proceeding and your life is at stake, life in prison, murder, that kind of thing. And you get less due process if it's a traffic ticket or a civil deportation proceeding. So just mentioning that because there have been assertions that we can't provide due process because it's too expensive to have capital crimes level due process for civil offenses, deportation offenses. That's not true. We have a process that is much less burdensome for those much less involved things. Back to our story. Justices, specifically all the justices, agreed that the Due Process Clause requires the government to provide anyone it seeks to remove notice that they are subject to removal under the Act, and to do so within a reasonable time and in such manner as will allow them to seek habeas corpus relief before being removed. In holding as much, the court effectively said that the Constitution flatly prohibits the government from doing exactly what it did that Saturday when it secretly loaded people onto planes, kept many of them in the dark about their destination, and raced to spirit them away before they could invoke their due process rights. As this opinion will shortly explain at greater length, the fact that the Supreme Court, etc., does not change anything. We're going to skip ahead now because the judge makes a further determination. But in between here, what the judge is going to talk about is the standard for finding for contempt. And I'm just going to sort of talk about it for a moment while I scroll all the way down to the page that I need. Contempt is the court's power to enforce its orders. It has various sources of contempt power, but the court has built-in or inherent contempt powers to enforce its orders. There's two kinds of contempt. There's civil contempt and there's criminal contempt. They're both used to coerce or pressure a violating party, a contemptuous party, to compel them to comply with the court's order. The most famous example I can think of in recent memory is Bradley/Chelsea Manning. I'll continue to refer to her as Chelsea, but just, Ms. Manning had, I believe, released some classified information and later was asked to testify about it before Congress or answer a subpoena about it, and she refused. And the court put her in detention under contempt to coerce her to testify. She was held in jail. She didn't testify, and eventually the grand jury she was going to testify before, it was a grand jury, the grand jury completed its investigation and was not disbanded. I forget the word. Discharged. The purpose of the contempt was only to compel Ms. Manning to testify. Once there was no more testimony to be had, the grand jury was discharged. She was released. This was not a conviction for a crime, although I believe she had one before that. This was a contempt proceeding because she wouldn't testify. That's what we're talking about here. In Garcia's case, the court is trying to figure out what remedy, what can it do? I'm on the wrong page, but what can it do to compel, to coerce, to more or less force the government to comply with the court's order? Skipping all of that. In sum, each of the defendants' arguments about whether there was a violation, arguments crafted for the most part as this contempt litigation developed, are at root attacks on the TRO's legal soundness and are therefore precluded by the collateral bar rule. Even if they were not, they do not pass muster. The court must therefore conclude that probable cause exists to find that defendants violated its order. Having so determined, the sole remaining question is whether such defiance was willful. To establish willfulness, the court must determine that defendants acted with deliberate or reckless disregard of their obligations under the order. Several aspects of defendants' conduct strongly support such a conclusion. From the opening hours of Saturday, the government's conduct betrayed a desire to outrun the equitable reach of the judiciary. Hustling class members to an airport before the proclamation had even been published, and in the face of a suit that sought a TRO, was bad enough. The decision to launch planes during the afternoon hearing was even worse. The government knew as of that morning that the court would hold a hearing on whether anyone in its custody could, consistent with the law, be removed pursuant to the act, and yet it nonetheless rushed to load people onto planes and get them airborne. Such conduct suggests an attempt to evade an injunction and deny those aboard the planes the chance to avail themselves of the judicial review that the government itself later told the Supreme Court is obviously available to them. Second, although defendants now seek to muddy the waters at no point on Saturday evening, not when the court delivered the oral command directly to the government, nor at any time after the written order was issued, did the government so much as hint that it was not clear precisely what action was prescribed or forbidden. After the oral command, the hearing progressed for another 5 minutes. Although the government spoke for the majority of that time, it never mentioned, much less asked the court to clarify, the injunction just issued. Government counsel has since confirmed that he understood the oral command and communicated it up the chain. Additionally, that night after the oral injunction was relayed to the agencies and as custody transfer operations proceeded, the government never contacted the court with any questions about the injunction's scope. That is telling. The government had been in regular email contact with Chambers throughout the day, and it thus knew that it would get a rapid reply to any question it might have about the injunction. Indeed, that is exactly what happened that morning. On the email chain that included the government, plaintiffs asked the court to confirm whether the first TRO covered only named plaintiffs, and the court replied 9 minutes later. Only now does the government suggest that the court ordered something less than what it unequivocally stated in the hearing. Finally, the government plainly had an opportunity to avoid noncompliance, and yet it chose to press ahead. As previously explained, the government pulled named plaintiffs from removal flights in response to the court's first TRO, and 2 class members now aver that they were among the 9 people who landed in El Salvador early Sunday morning but were later returned to the U.S. Although defendants maintain that they did not order any removal flights to return to the U.S., they offer no evidence to support that assertion or discredit the first-hand declarations of the class members. Taken together, this behavior indicates deliberate or reckless disregard for the order, leading this court to conclude that there is probable cause that defendants willfully obeyed a binding judicial decree. So now what? The court last details the next steps that these proceedings may take. First, before initiating any criminal contempt proceedings, courts typically allow the contumacious party, the offending or violating party, an opportunity to purge its contempt, that is, to remedy its violation by voluntarily obeying the court's order. A court should first apply coercive remedies in an effort to persuade a party to obey its orders and only make use of more drastic criminal sanctions when the disobedience continues. The district judge normally will preface a contempt citation with an order directing compliance with a subpoena or a showing of an excuse for noncompliance. The most obvious way for defendants to do so here is by asserting custody of the individuals who were removed in violation of the court's class-wide TRO, so that they might avail themselves of their right to challenge their removability through a habeas proceeding. Per the terms of the TRO, the government would not need to release any of those individuals, nor would it even need to transport them back to the homeland. The court will also give defendants an opportunity to propose other methods of coming into compliance, which the court will evaluate. In the event that defendants do not choose to purge their contempt, the court will proceed to identify the individuals responsible for the contumacious conduct by determining whose specific act or omission caused the noncompliance. At the suggestion of the government in the last hearing, the court will begin by requiring declarations. Should those be unsatisfactory, the court will proceed either to hearings with live witness testimony under oath or to depositions conducted by plaintiffs. The next step would be for the court, pursuant to the federal rules of criminal procedure, to request that the contempt be prosecuted by an attorney for the government. If the government declines, or the interest of justice requires, the court will appoint another attorney to prosecute the contempt. Finally, a note on defendants' invocation of the state secrets privilege, which permits the government to prevent disclosure of information when that disclosure would harm national security. They invoke the privilege as a ground for not providing certain details related to the movement of flights and class members before and after this court's TROs. Sharing such details, they assert, could make foreign countries less likely to collaborate with the U.S. in the future, and would disclose means used to thwart alien enemies, allowing them to evade capture and risking the security of removal personnel. Defendants also add that there is no need for the information in this case, as the court has all of the facts it needs to address the compliance issues. Judicial review of a state secrets invocation is circumscribed, but not non-existent. The government's claim is to be afforded the utmost deference, and the court must evaluate whether there is a reasonable danger that compulsion of the evidence will expose military matters which, in the interests of national security, should not be divulged. The state secrets doctrine does not represent a surrender of judicial control over access to the courts. The court is exceedingly doubtful that the privilege applies here. It is not inquiring into the diplomatic agreements that facilitated the flights, nor the operational specifics of how defendants apprehended and transported class members. The court is seeking to confirm times and numbers, how many passengers the two flights carried, whether they were all deported pursuant to the proclamation, when they were transferred out of U.S. custody. The court is skeptical that such information rises to the level of a state secret. As noted, the government has widely publicized details of the flights through social media and official announcements by reposting video showing operational details, thereby revealing snippets of the information the court seeks and raising doubts that such information would jeopardize future diplomatic engagements or operational security. Defendants, moreover, have still not asserted that the information is classified, and they have identified no case in which unclassified material was nonetheless protected by the privilege. Nor is the court yet persuaded that even if publicly disclosing the information might harm state secrets, sharing it only ex parte with a federal court would do the same. At this point in the contempt inquiry, however, the information at issue is not necessary to proceed, so the court will not resolve whether the invocation is warranted. But if the information turns out to be necessary later in these proceedings, the court may revisit it. For the foregoing reasons, the court will find probable cause that defendants' actions constitute contempt. It will provide them an opportunity to purge such contempt. If they opt not to do so, the court will identify the contemnors and refer the matter for prosecution. A separate order stating so will issue this day, April 16th, 2025, by James E. Boasberg, Chief Judge of the District of Columbia, the D.C. District Court. His order then: given the finding of probable cause for contempt, the court orders, if defendants opt to purge their contempt, they shall file by April 23rd a declaration explaining the steps they have taken and will take to do so. And if defendants opt not to purge their contempt, they shall instead file by April 23rd declarations under penalty of perjury. That's a criminal charge. Declarations identifying the individuals who, with knowledge of the court's class-wide temporary restraining order, made the decision not to halt the transfer of class members out of U.S. custody on March 15th and 16th, 2025. When we said the words constitutional crisis, this is it. This is the constitutional crisis. Does the court have the power to make the Trump administration return Abrego Garcia and other victims of this deportation sans proper finding of removal after a hearing within the requirements of due process? Why am I using such a vague language? I'm not an immigration attorney. The courts that do this are not regular courts. They do this in sort of a rocket docket. It's a minimal due process. So we're asking, we people who believe in the rule of law, and here Judge Boasberg, who also believes in the rule of law, we are asking for due process for these people. These people should never have been sent to a prison, let alone a foreign prison, let alone a foreign prison made to house terrorists, without a hearing. Assuming they wanted one. If they didn't want one, okay. If they go voluntarily, that's fine. But if they want a hearing, they should have the right to a hearing. Duh. So,
hearing is the sensory process of receiving and perceiving sound. It involves the detection of sound waves by the...
Gemini is the worst. Absolute worst. So, I looked up some things. This has happened before, but not like this. There have been rare instances in U.S. history where presidents have defied or disregarded court orders, but such actions are exceptional and controversial. Andrew Jackson in Worcester versus Georgia. President Jackson is famously associated with defying the Supreme Court's decision in Worcester versus Georgia, which held that the state of Georgia had no authority to impose its laws on Native Americans in their territories, in Native American territories. Justice Jackson, oh my God, don't do that. Andrew Jackson, president, reportedly responded, John Marshall has made his decision, the Supreme Court Justice John Marshall. Now let him enforce it. Jackson's defiance led to the forced removal of the Cherokee Nation along the Trail of Tears. Abraham Lincoln, in Ex parte Merryman, in 1861, during the Civil War, President Lincoln suspended the writ of habeas corpus without congressional approval. Chief Justice Roger Taney, in Ex parte Merryman, ruled that only Congress has the authority to suspend habeas corpus. Lincoln ignored it, citing the rebellion and public safety concerns. Richard Nixon, in the Watergate scandal in 1973. In the midst of the Watergate scandal, remember Nixon's political party raided the offices of the other political party at night. I was kind of captured in Forrest Gump. President Nixon initially refused to comply with a subpoena to release tape recordings. The man had made tape recordings of his crimes. Please, everyone make tape recordings of their crimes, please, especially Donald Trump. The Supreme Court in United States v. Nixon unanimously ordered him to deliver the tapes. Nixon complied with the order, which eventually led to his resignation. So, what the hell happens next? We don't know. Legal scholars do not know. No legal scholar in the country is going to be able to tell you what will happen next. We are in uncharted territory. The court should be able to visit contempt proceedings on someone, but what will the court be able to do if the administration continues to stonewall and doesn't throw someone under the bus? The court will have to continue its investigation, and we will have to see how creative Judge Boasberg and his colleagues get in crafting restraining orders, crafting discovery orders, crafting contempt orders to somehow compel the executive branch to comply with its obligations under the law. I cannot stress enough how important the three branches of government are, that they exist to check each other and balance the conflicts between laws and people and government and etc. And we are currently in a situation where the executive branch is testing the other two. Congress seems to have already folded and bent the knee. I professionally expect, in my legal opinion, I expect Congress will do nothing to stop the Trump administration. What Congress should do, the real remedy here, is Congress should impeach and remove. And then later, prosecutors can also prosecute. Again, Justice Department under the current executive branch, I don't expect that. So Judge Boasberg is proposing that if he makes criminal contempt referrals, and if there's no prosecutor that will prosecute, he will appoint one. So that's like when maybe the executive branch or the Department of Justice appoints an independent counsel to investigate something so that it looks neutral, that that the prosecutor isn't working for the executive branch. That they're investigating. It's a huge conflict of interest if you're not getting where I'm coming from. So we're in this constitutional crisis. Judge Boasberg is going to potentially issue an order appointing a prosecutor who will then prosecute the perjury or criminal contempt. And then what? They get prosecuted, and which police are going to arrest them? Are they really going to order the U.S. Marshals that work for the judicial branch to arrest members of the executive branch? It's probably the last thing the judicial branch wants to do. It's probably the last thing that you'll see. Not anywhere on the table right now. As much as I know some of us would love to see something to help the poor people who were deported illegally, and especially the innocent people who were deported illegally. When we say it is better that 10 guilty men go free than one innocent man goes to prison, that's the due process. That's due process. That's the beyond a reasonable doubt standard. That's the conviction standard, the criminal conviction standard. These are the protections that we all agreed to in the social contract that is the U.S. Constitution, that we would never do anything like this to someone without a hearing first. A meaningful hearing with an opportunity to respond and be heard, etc. So the lack of understanding of the basic legal principles in the U.S. it's pathetic. It's sad. It's disappointing. People should be aware of their basic rights, and that the fact that they're not, or that they're willing to give up their rights so quickly so that they can hurt someone that they don't like. I'll leave it with this. Benjamin Franklin once famously said, it's a democracy if you can keep it. And also, he who would give up freedom for security loses both and deserves neither. Thank you all for your support. I love you all. Have a good night. Thank you to my supporters. There's a couple of you listed in the thing who support me at the highest level that I really appreciate you. You've been there for me for a very long time. Eevi, John Steele, Ugly Grill, TechTechPotato, the Blood-Soaked Survivors, and Kyle Siefring. Thank you very much, everyone, for all of your support. I will make more videos on this subject, this unfortunate subject. I love you all. Have a good evening.